Welcome to the space where law meets legacy and paperwork meets power. This ain't your average legal game, this is decoded law, next level accounting, and real world securitization, taught by the sharpest mind in the field. He's not just teaching law, he's redefining it. Breaking down complex codes and contracts like it's second nature, whilst exposing what the others won't even whisper in court. Powered by the Supreme Elite Team University, this is the new culture empire where the future is educated, executed, and elevated. If you're here to learn, get your pen. If you're here to argue, get your paperwork tight. Let's get into it.
Okay, so just as expected, I was removed from the group.
Welcome to another episode of Are You Afraid of the Dark? In this episode, Thomas breaks down the difference between the court filings that you see from sovereign citizen social media gurus like Pernell Elliott Williams and the use of the Uniform Commercial Code like it's the court rules. You will, once again, witness the masterful display of Thomas' court filings and the unprecedented motion for summary judgment filed on behalf of his client, and how no social media guru can ever get to the summary judgment stage as the filer and not the defender of it. And don't forget, the Supreme Elite Team University enrollment is now open.
As expected, I was removed from the group. Hey, yo! Hey! I scalped him in this old comments. Look. He removed me from the group. So this guy was talking about his cases are unmatched. His lawsuits of Pernell Elliott Williams. He said his lawsuits and filings are unmatched. Now, you know, anytime someone comes and says that and they are not a legal professional, you know I would feel some type of way. Because in reality, my lawsuits are unmatched.
You're rocking with the
And
best.
no one wants to stand toe to toe with me in pro se litigation filings. Everybody runs. As you can see here, he ran. Content isn't available. Remove me from the group. Now he posts his case, Pernell Elliott Williams versus LVNV LLC. I have plenty of cases regarding LVNV when they were scalped by the judge. Of course, these people, this is the mindset. They bring the UCC sovereign citizen mindset into the courtroom. They don't file lawsuits in conjunction with the court rules and procedures and relevant case law. They file lawsuits based on their beliefs of the system. Hold on, don't tell me. Hold on, give me 1 second, y'all. Let me see if I can pull his cases up. Now let's read this. Oh, by the way, Pernell Elliott Williams, if you're going to post your case and you post this, because he posted on his Facebook page, my lawsuits are unmatched. When you're going to purposely lie to people, make sure you block out the case number so people can't look it up. Complaint for damages and injunctive relief. Number one, it's not even a legal caption. Plaintiff, Pernell Elliott Williams is a secure party agent for the estate of Pernell Elliott Williams. Right then and there, hold on. Represented by this UCC1 finance statements and is a non-citizen state national who has fully secured rights all over his legal fiction, including the use of a social security number. Right there, he lost his case. Sovereign citizen. Right there. The judge sees it.
Right there.
Sovereign citizen. Right there. Paragraph, lost his case. Frivolous, sovereign citizen. That fast. And this is the person that said, my lawsuits are unmatched.
serious?
The UCC to these people, that's the court rules to them. They think the UCC applies in court in the way they cite it. Remember, us professionals, we do motions and pleadings. With them, they do affidavits and notices. How can you grant the court's jurisdiction over the relief that you seek when you say you are a non-citizen state national? When the 14th Amendment clearly says anyone born or naturalized within the United States or within the 50 states, you are a United States citizen and a citizen of the state where you reside. It's not if you want, or it's not, it was non-negotiable. That's how they look at you. Regardless. Not about you can choose your citizenry.
No.
Right. You cannot choose your own citizenry. It's non-negotiable. If you are born in the United States of America or naturalized, you are deemed a United States citizen, regardless of how you feel. And this is the difference. They do things based on what they believe or what they feel versus what it is. And this is why 99.99% of these people just floating around in these spaces are not going to get any closer to the results they seek in 2026, just like they have it for 2025. There's nothing that's going to change in 2026 for these people. It's all going to be the same thing. They're going to waste 5, 10, 15 years in these spaces just wasting their life away on frivolous ideologies and beliefs that has no legal basis in law or fact. Defendants, LVNV LLC, Resurgent Capital Services, have willfully violated plaintiffs' legal rights, including the misuse of plaintiff's social security number and other identifying information, which plaintiff has secured under common law copyright, a commercial security agreement, and a UCC-1 financing statement. So the common law copyright, the commercial security agreement, and UCC-1 financing statement, that comes as when you buy the redemption manual, the version from 1998. When you buy that version, it comes with those exhibits in the back that you could just tear off and file. It comes with it. See, that's the thing. Everything that he's studying is nothing but the old. There's nothing new here. Common law copyright. We're not in common law anymore. In order to copyright, you have to go to the United States Patents Office, and the headquarters are in Alexandria, Virginia, and do it the legal way. But they think we still reside in the 1800s where everything was common law, not knowing the courts don't, or the government, they don't operate under common law. There are no more common law courts, because if they would have read the Erie versus Tompkins case, I think 1938, that was one of the cases, and the years right around those years, so for 1933 through 1940, actual common law courts have been taken out. And this is why you have civil courts and you have criminal courts, because the civil courts is where common law can be applied and you can get equitable relief. This is why foreclosures are equitable reliefs. Mortgage, autos, these are equitable reliefs. But they actually think there's an actual common law court that you can step into to get the release. And this is all matter of public knowledge. So if you don't even know this today, it's like you're never going to get it. And someone said, well, if I'm so wrong, tell me where I'm wrong and tell me. I said, no, I'm not supposed to tell you. I'm not telling you anything. You're supposed to know. If you don't know it by now, go back and research, or you're never going to get it. See, they think they can bait me in on giving up the sauce. And this is how you know how far these people are falling from grace. When I cite court cases that disputes the same post that the gurus is posting, and I don't believe all of them follow them, because some people in those posts was like, yeah, this is sovereign citizen. You don't know court. So when he filed and said, hey, look, they're trying to sanction me, y'all. It was like, because some people was like, you don't know law. because you're doing that sovereign citizen stuff. So there was some people's like, man, that's cold-blooded BS. This court has jurisdiction under 28 U.S.C. 1331. No, they don't. Not over those sovereign citizen claims. In 1332, the cause of action arises from defendants violate plaintiff's rights under federal law, including Social Security number privacy laws, UCC 1 security interests, and common law copyright protections. None of those have legal validity. The courts have jurisdiction over those frivolous claims. They have no jurisdiction. They're frivolous. There's nothing in law and fact that supports his contention that they have jurisdiction. Venue was proper under C-39 because defendants do business in the district and is a substantial part of events giving rise to the claims occurred here. Plaintiff, Elliot Wood, defendants. Plaintiff sent an official cease and desist notice and Scott Gutierrez on around May 2024, demand that defendants cease the reporting, use, or dissemination of plaintiff's social security number and any unauthorized use of plaintiff's collateral. Number one, how is reporting the obligation that you owe violating the law?
If you're doing it, stop it. Get some help.
Remember, all they do is say they did it so wrong, but where is the factual allegations to back it up? And do I really want to know why they never have case law to back up their sovereign citizen claims? Because none exists.
You need help. You need serious help.
We're all denying the same claims that they're about to attempt to use. So what do? Remember, it's a mindset and belief system for them. So they can read a court case, multiple, that's denying the same claims they're about to attempt. Instead of going back to the drawing board and not submitting it, since they believe it's true, they're going to submit it anyway and then act surprised when it gets thrown out. Because when their sovereign citizen claims gets thrown out, they all believe that the courts is trying to stop them from their expressing their rights. Like it's one big conspiracy theory against them now.
This is just a conspiracy. It's a conspiracy.
And more than likely, this all stems from a just trying to get out of his debt and not trying to pay a bill. They use the sovereign citizen methods as a cover up for not paying a bill. And this is the mindset of hundreds of thousands of people in this space. This notice was duly served via certified mail to the president, yet defendants failed to comply with the notice because you didn't follow the proper chain of title. What makes you think that the president is going to read any letter from you that's unsolicited? In order to send, you have to go through the president's secretary. They have to know it's coming. You cannot send, a consumer cannot send unsolicited mail to the president of a, look. This is the difference between people with a professional mindset because we already know these things. Plaintiff sent a debt verification request to the CFO on May 16, 2024, pursuant to the Fair Debt Collection Practice Act 15 U.S.C. Section 1692, requesting verification of the claimed debt. Now, here's the thing. I guarantee you it was some wet blue ink signature. I guarantee you with some identify me, that's not me, that's the all caps, that's the corporation, identify me as the human being. My name is spelled in all caps, that's not me. I got a UCC 1, I own that, not me. See how stupid these people sound? And all that's going to drop to the wayside, they hit the lottery for $5 million. That sovereign citizen shit gonna drop to the wayside and they're gonna go back to being a major consumer. Defendants continue to report the debt and plaintiff's social security number to third parties, violating plaintiff's rights under federal law. What federal law did they violate?
We have no idea what you're talking about.
I mean, I'm pretty sure in every agreement, they're gonna report whether you're making your payments right to the credit agencies. So what do you mean? Defendant sent copies of the plaintiff's credit card statements from his creditor Defendant sent copies of plaintiff's credit card statements from his creditors and not a contract or debt with LVNV LLC. Nobody knows what it even means. Violation of UCC1. UCC1 is not even a statute. It's a form.
You need help. You need serious help.
Violation of UCC1. I told you, they think UCC1 is the law. It's the holy grail. They think the UCC is the holy grail of court actions. A UCC1 is a financing statement between a legit debtor and legit creditor. And debtor is never the creditor's name spelled in all caps. But the redemption manual and the ideologies have told people for the years, take control of your straw man. File it as a transmitting utility. What does transmitting utility mean? I don't know. It's just part of what I was taught. A public finance transaction. Oh, so you are a electric company that doing business in the state? That you issue bonds and stuff? You raise municipal bonds and stuff for this? Is that what you're doing? No, it's just my all caps. What's your collateral consist of? My driver's license. Oh, let me guess. That's a contract too. That's the security too. Your driver's license, right? Your application, right? Let me guess. What else you got in there as your collateral? Your social security number. I bet you got the back letter and the 8 numbers on the back of it too, don't you? Federal Reserve Bank trace number, You got that on there too. What else you got in there? Oh, you can't forget this. You got your birth certificate in there too, right? Oh, you got your registrant number on there too, don't you? What else you got in there? Your security agreement. Between you and yourself. Yeah. That's a decent financing statement. Defendants have used plaintiff's SN and other identifying information without authorization in violation of plaintiff's secure party interest as established under plaintiff's UCC1 finance statement, which was filed in 2024. So you give them your social security number, filled out the application to get whatever transaction. So you gave it to them. And if you probably read the contract, it says that we're going to report to the credit bureaus and all that. And then they have the notice of the fair debt, credit reporting act. So you already knew they was going to do it. But ever since you filed the UCC1, when you become woke, now you could just unilaterally change the terms of the contract. Amazing. Amazing. Common law copyright violation. None of that can ever be enforced in court. It's a googly gop. It means nothing.
Emotional, damn it.
Defendant's actions, including the unauthorized use of plaintiff's legal fiction. Plaintiff's legal fiction. Can you just imagine a legit, I know every time these sovereign citizen gurus file lawsuits in their own name or behalf of their clients, I know they're licking their chops. If I was a lawyer defending it, oh my gosh, I'd be in heaven every time I see a filing like this. Damages to creditworthiness as a direct result of defendant's fraudulent actions. Still hasn't said what was fraudulent. Plaintiff has suffered significant damages to his creditworthiness due to incorrect and fraudulent reporting to the major credit bureaus. This violation has led to severe financial injury. No, it didn't. No, it didn't at all. Because look at this section. We had 12. Look what he filed it under. Factual allegations. Okay, I thought it was factual background. Okay, so let's see if he gets to the standard of review. Let's see if he gets to the case citations. Let's see if he gets to the case citations now. After you got the factual allegations, now you get to your arguments. Now let's see if he has case law. Let's see if he has case law to support all 12 claims. Let's see if he has case law to support it. Let's see if he has authoritative case laws and court precedents to support his claim. Let's see. Nope. He goes straight to claims for relief. You want to know why? Because they never find case law to support their allegations because they know none doesn't exist. This is all sovereign citizen belief filings.
Checkmate.
Where's the case law at? You got factual allegations. Well, if you're filing a complaint, all your allegations have to be backed up by factual evidence and case law to support it. These are the federal court rules. So you've already hasn't complied with the federal rules just by filing this. Where's your case law at? Where are case law where courts have agreed that damages such as the ones LVMV committed towards Pernell Williams have been awarded to other plaintiffs? Where's the case law at? You don't see no case law because none exists substantiating this garbage.
What?
Claims for relief. Look at this. Violation of cease and desist notice. Where's the case law supporting violations of cease and desist notices? What case law can you pull up that when you send a cease and desist notice that they're supposed to just stop or it's a violation? What is a cease? What type of legal enforcement does a cease and desist notice have in the court of law? Absolutely nothing. It's just a request to stop. There's no violation of it. Either they're going to stop or they're not. If they don't stop, then you just bring a lawsuit alleging the damages that were communicated in the cease and desist. You don't bring a lawsuit because they violated the actual cease and desist notice. The correct term would be a gag order. But obviously you ain't getting a gag order with this garbage. You see how we can just pick these gurus apart, y'all, effortlessly? That we just picking them apart. Just picking them apart. And he ain't the only one. Pernell Elliott Williams, there's about 150, 200 groups on Facebook. They're all saying this garbage. And they all lying to the people like they're going to get them a win. Plaintiff alleges and incorporates by reference all prior paragraphs. Defendants continue use of plaintiff's Social Security and reporting of fraudulent debts despite receiving a cease and desist notice constitutes a violation of plaintiff's legal rights under federal and state law. What federal and state law did they violate, and how was the debt fraudulent? How, you haven't even substantiated how the debt was fraudulent. Oh, they have all the talks. And you know one thing I noticed? When they're making these posts on Facebook and other platforms, they can explain left and right how the debt was fraudulent, how you don't owe the debt. But as soon as it gets to court, it just becomes very vague. Why didn't you get into detail like you always get into detail in your Facebook posts? Oh, because you can't find any legal citations to substantiate it. Oh, I get it. So you're just talking to the people, painting a picture from them. But when you go to court, you're very limited. Not one case citation. Damn gurus. You've been researching this stuff for, you look like you just started. This is old 1995, 96 type of arguments here. You ain't even step up to the late 2000s sovereign citizen arguments. This is 1996 shit here. I done seen common law copy. That shit's for like the early 90s. But let me guess, they think it's something new they just researched. Violation of UCC1 financing statement. Where's the case law on that? How can you prove in court through factual evidence that violation of a UCC1 finance statement is a violation of state law? You know what's a violation of state law? Filing a false and frivolous financing statement, which I believe that financing statement was rejected and stricken from the record. I totally believe that was the case. But y'all know they'll never show you when they strikes their fraudulent UCC1 statements. But I will give him credit for posting the motion to sanction him, even though he tried to spin it like, look what they just tried to file against me.
Yeah, I don't get the
So,
point of why he did that.
well, I don't even know why he even posted it. But I'm glad that he did. At least he was being a little bit transparent, because all these other teachers, they just would have swept this under the rug and continue teaching. And this is the part what they do when they stop trying it on their own. But this is the part when they stop trying it on their own and they just trying to make a profit off the ideology now. A lot of them go for that. Trust me. A lot of these teachers, they've already tried it, lost, know they're not going to win, and they just sell it to people who believe in it. That's all they do. Violation of SSN privacy laws. Defendants' unauthorized use, sale, distribution of plaintiff's SSN constitutes a violation of federal privacy laws. How did they violate it? What did they do? Who, what, when, where, how? You said the word fraudulent, like fraudulent debt. So now the pleading standards have been heightened. Where's the fraudulent? Where's the fraud at? You have not alleged fraud. I mean, you have alleged fraud, but you have not pled fraud and met the heightened pleading standards under federal law when you allege fraud. Where's the who, what, when, where, how? Who did what? When did they do it? Where and how did it damage you? And you don't see not all vague. This. He's not the only one. Every single one of these gurus filings are going to look like this. And the ones who got a little bit of understanding of case law but don't really understand, they're going to misquote statutes, misquote the context of the cases that they citing. I told y'all, less than 1% of pro se litigants ever win in court. That's not a joke. Less than 1% ever wins. Do you know how many things you have to know before you even think about filing a lawsuit about court? Do you know how much ground you have to cover? Like, I've been in the court system, like documents and stuff, since 2012. You see, I get what I'm saying? Since 2012.
Absolutely.
Pro se, I had a lawyer. I just didn't come out the blue with this. I've been knew about court. Even when I first started, I've been knew about court rules, court procedures. Common law copyright infringement, of course. No case law. Defendants unauthorized use of plaintiff's legal fiction. That's not even, y'all know that has no legal law basis. That basically he's saying straw man. So when the judge gives this order of opinion, all he's going to do is says, it appears that the plaintiff has adopted the sovereign citizen redemptionist theory, in which courts have consistently rejected as frivolous. He knows that was the order. So they threw the case out and they probably gave him 14 days to file an amended complaint. Violation per month. You know what this means now, damages? You know what this means? Broke, destitute, in a financial bind. Just everybody that files stuff like this with these outrageous numbers, they're in a financial bind. Every single one of them. Because even if we just go, let's say I give them the Fair Debt Act. The statute poses limitations. I think it's like a fine up to $1,000 per violation. So the statute calls for a limitation on the amount of damages. It's called a money mandating statute. But he'll come in with a $15 million per month on a cease and desist violation with no case law to support that violating a cease and desist order gives you a right to monetary damages in court. See, they file lawsuits based solely on belief systems, not under the court rules and procedure. As a result, defendant's action, plaintiff has sustained the following damages: $15 million per month from May to January 2025 for violating the cease and desist notice and UCC1 financing statement. Once again, it's a frivolous assertion. There is no case law to support there is not even a term violating the UCC1 finance statement. That term has no legal basis. $25 million for the violation of plaintiff's common law copyright. That is a fraudulent term. You have to get a copyright through the legal means by copyrighting it with the government. And then if anyone violates that your copyright, you can send a cease and desist notice for copyright infringement. If they don't stop, then you can what? Sue them in court for copyright infringement. But you got to have something to copyright, not your all caps name. And I'm telling y'all, these people will never figure the system out. The way they think the system operates is totally different from how the system really operates. The problem is they're so far gone down in their frivolous belief systems that they can't admit to themselves that everything they've been studying has been wrong. They refuse to admit it, and they're going to hammer it down. Total damages, 265 million, which includes all damages outlined for violation. Look at this. Look at this. SSN privacy, copyright copy law. Right. Now, guess what? Look, he thought he was doing something too. And this case was dismissed. This case was dismissed as frivolous.
For real.
Look at it right here. Order signed. Case terminated December 23rd, 2025. Case terminated. Oh, over. See that order? That's the one I wanted you to get right there. Look, response to defendant's motions for Rule 11 sanctions by Pernell Williams. You see that? That was the when he posted on Facebook, the one I shared to my page, and he took it down and removed me from the group. They filed a motion to sanction him for filing frivolous claims. Look at this. This is him, LVMV. This when he filed the case. Okay, yeah. Look, order proposed. Now look at this here. Response to defendant's motion for Rule 11 sanctions. I would love to see that. Now look at this. Notice of power of attorney. Order for proposed scheduling order. Right. Look at this. Disclosure statements filed. Answer to complaint by Resurgence Capital. That's what I wanted. A response to the answer to complaint. Status report. Notice of change of address. Now all this right here, he got this thrown out as well. He got the other one thrown out, and that's the Rule 11 sanction where they sanction them at. Now let's get to real law. So, and this is the part where they're really, well, not this part yet. I'll let it play on. I'll let it play on. So we have, right? They had a summons against her. You are hereby summoned in a complaint, a copy of which is here to attach and made a part has been filed against you in this court by the plaintiffs, Velocity Investments. You are required to serve before the plaintiff's attorney, boom, 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 within 28 days of this summons. She came to me damn near, like, by the time I actually got to it, she came to me 10 days before. By the time I actually spoke to her, we was like 3 days before there was about to be a default judgment. 3 days. So she was slumming and oh, here we go. I'm gonna have to do it like phone upside down. We gotta do it this way. So, Velocity Investments. Plaintiff acquired for valuable consideration all right, title, and interest. I hate when it does that. Same for there is due from plaintiff a sum of $17,314.84. A copy of said written agreement is attached as Exhibit A. Plaintiff notified defendant of the assignment and demanded that defendant pay the balance due on the written agreement, but no part of the foregoing balance has been paid. Wherefore, plaintiff plays for judgment in the amount of $17,314 with interest statutory date. Okay, so they filed the suit. Tell me you're still there. So they filed the suit, and in this, we responded. He responded here. In the matter involving plaintiff in velocity investment, the Ohio trial and appellate courts repeatedly note that filers will not permit a debt buyer to survive a properly supported challenge in discovery or on summary judgment. Do you see how different that sounds from Pernell Williams? You see, it's legal. It's money that you can feel confident in spending in a legal suit. Will not permit a debt buyer to survive a properly supported challenge in discovery or on summary judgment. So you saw how I was priming the judge for it. See, I was throwing it out there. Here, this is exactly what plaintiff did when they found it's only. In the matter involving plaintiff in velocity investment versus, oh my gosh, the same people that's suing her in this, highlights that plaintiff's attempt to seek a judgment against me, the defendant, by submitting documents that were admonished by the appellate court / the judicial system right in the face. The court scrutinized Velocity's litigation tactics by emphasizing that a debt buyer cannot prevail merely by from the creditor. Here, plaintiff has done exactly what the court warned against. It found only in it identifying Lending Club as the creditor. As Ohio courts have made clear, means not, and plaintiff's failure is fatal to its claim. Plaintiff's attempt is legally insufficient. Ohio law requires that a debt buyer to the plaintiff must exist as and cannot be cured paper. I had an epiphany. I have deja vu. I got deja vu, y'all. This sounds familiar. What, we just saying the same thing in a mortgage case? Oh. The core elements never change. You figured out the system. This is a debt buyer case, same element. UWM, same element. Auto, same elements. Credit card, same elements. Mortgage, same elements. Same elements.
You're rocking with the best.
Once again, the court held that. Wow, I just had another deja vu. I felt like I'm reading the same thing. Oh, that was the UWM case. My bad. I was making sure I wasn't confusing filings. I thought I was reading from the UWM case law. My bad, y'all. See, once we understand that 1% of the game, they're stuck forever. That means they lose from the beginning. Now just look at Pernell Williams Elliott's. Plaintiff, Pernell Elliott Williams is a secure party agent for the estate of Pernell Elliott Williams. Right then hold on. Represented by this UCC1 finance statements and is a non-citizen state national who has fully secured rights all over his legal fiction, including the use of a social security number. That's the representation of everybody out there. This is why the Supreme Elite team is unmatched. As a matter of fact, we'll rival a top litigator law. One of my clients in 2025, not every single one of them surpassed the initial stage. Every single one of them went to civil pretrial. The original the plaintiff filed do not meet the requirements that courts have repeatedly rejected. In this case, plaintiff has done the exact same thing, and this court has failed to dismiss the claim for failure to state a claim. That's when I got on the judge. You knew you should have threw that out. Right when I filed my motion to, you knew you should have threw it out. That's why I handicapped your way. I knew you were supposed to grant it from the jump. But the problem is, it's hard to get these type of motions at the jump because the threshold, you got the evidence. You see what I'm saying? Their standing is so low. Or you're filing a complaint for a judgment, but non-payment of money, you got the debt. I mean, it's hard to get it thrown out. I'm still going to try. All they're going to do is say, overruled, you got to respond. And then it gets to the proceedings. Because in reality, it's premature when I move for a motion to dismiss right there. It's really premature because they already met the burden. I mean, it's very low for them. Hey, file a complaint, attach the debt. The burden is low. It's up. The burden shifts on the defendant to invalidate the complaint. Y'all get what I'm saying? You get what I'm saying? The burden's on us. So I know it's going to get overruled. But I'm still going to shoot it out there because you never know. It's premature. I knew the odds of it getting granted at that time was very low because it's not even the right time to do it. But it doesn't hurt. See, every time I step outside the box, it doesn't hurt me or my client. In this case, plaintiff has done the exact same thing. And this court has failed to dismiss the claim for failure to state a claim, allowing plaintiff to cure this defect should not be allowed because the Ohio statute and case law is very clear, must be entered, as well as this court's jurisdiction over the plaintiff's claim. Gotcha, judge. So remember that I made a video about this saying I handicapped the judge? I filed a motion to dismiss, knowing that it was premature, knowing that it may get denied at this stage, because if you look right here, judge's response. So I was ordered to respond. Now, most people would say, well, if you filed the same things, double down on your position in your actual response, then to your motion to dismiss, there's no way that the case is going to move to pretrial or a conference. They're going to get awarded. Because you didn't win your motion to dismiss, right? Dismiss, right? Now, look at the yellow highlighted. You see? I pretty much handicapped the judge and not giving them a judgment right at the beginning because they wanted a judgment. But what I did with the motion to dismiss, I laid the trap and then I came back with the response that pretty much handicapped the judge. Now it's our turn. Now we're about to move for summary judgment. And this is going to be another. So thinking back 2020 hindsight, it was impossible for the judge to give him a judgment after this, right? Right? It was impossible. Right. It was impossible. He couldn't. I knew he couldn't. I said, he can't give him a judgment off this. You want to know why? Because all we're going to do is just take it on appeal and win in 2.5 seconds. It's going to make him look bad. As stated in defendant's motion to dismiss, this court does not have subject matter jurisdiction to hear plaintiff's claims because plaintiff has not complied with the requirements to bring such claims and thus has failed to state a claim upon which relief can be granted. Just as in Midland, oh my gosh, I got a scalpel coming to Midland. I will scalp Midland in my sleep. Midland. People are like, Thomas, I got Midland. I'm like, Midland. Come on, let's go. Excuse me. Midland. If anybody got Midland, please holler at me. Man, I know their company inside and out as well, too. And that's one of the things I did, y'all. I didn't just study credit side. I didn't study this. I literally studied about a good 30, 40 of these people. Like, you want to know why? Because I didn't just want to know what I can do to defend myself and my case or other persons. Not other person. I wanted to know the system, all the core elements of the system, how the system operates. Want to know why? Because that allows me to take on people's cases, all wide range of different cases. We can go to bankruptcy, we can go to state court, we can go to federal court, we can be the plaintiff or we can be the defendant. It don't, but that's like, once again, I'm gonna tell you, I'm not just a person that popped up 3 years ago. Y'all, I was really doing this before any of y'all ever knew me. before I even came to YouTube. I had like 8, 9 years in studying already. I get what I'm saying? Like case law reach. I had like almost a decade in already.
Oh, I know. I can tell. I've been through that.
Mm-hmm.
Yeah,
Anybody
bro.
could, anybody you could tell been doing something for a while versus these fly by night. Was a student in this group. 2 years later, now you're a teacher, because you know what separates. You could tell it comes out in your understanding. You get what I'm saying? Like you only go as far as your understanding and your knowledge. So you could tell when these teachers, their knowledge is limited. Yeah, I get what I'm saying. Like you could tell where it stops. I haven't circled the wagon yet.
You're rocking with the best.
Yeah, I know. Y'all been in my group since 2022. You know, everything has been a steady climb through the years. Is it keep getting better? Actually, Tahir, no, he's been here longer than any of y'all. Tahir came to me about March, April 2022. At the ground stages of this. He's been here the longest. And he's been in this stuff longer than me. Tahir been on these spaces way longer than me.
Let's pause for a moment of clarity where Thomas explains to his group what other gurus will never do with their students. The reality of paying your bills that you legally owe and nothing more.
Hey, it's nothing wrong with paying it. I don't know why. That's what I'm saying. I don't know why people think there's such a bad thing for paying your mortgage, especially that. It's not a bad thing. It's not a bad thing for paying your credit card, but it's really not a bad thing. It keeps the line of credit open. Like, it's really not a bad thing for paying your bills on time. It's not. It's really not. I don't ever want that to go to waste. There's nothing wrong with paying your bills. No, there's nothing wrong with it, ladies and gentlemen. I'm not shaming it. As a matter of fact, it builds character. It shows that you're trustworthy. It shows, it's a lot of good things that come with it. Paying more than what you legally owe is the issue. Do y'all understand the distinction? Do y'all understand my mindset?
Right. And that's one of the things that
brother, like 100%.
Yeah, none of this is never, I'm doing this to get anybody out of a bill. No, none of that is ever the issue. I'm never arguing from that position. I'm arguing from, hey, we don't mind paying the bill, but we just mind paying any more than what we legally have to pay. That's it. That's it. Just as in Midland, where plaintiffs do, as plaintiff has done here, without a courts, and this court shall treat such filings as inadequate to establish, have as this court should dismiss or refuse to enter judgment. See Midland version. The trial court erred in granting judgment. Hold on. See Midland funding. That court held the trial court erred in granting judgment to Midland, where the only evidence, the absence of a failed to. Why do you think out of that whole case I read, I cited that? Who was I talking to in that moment?
The judge.
The judge. I was speaking directly to the judge. Plaintiff in this case has not even under plaintiff lacks standing. And the court ruled that a debt buyer must establish. Plaintiff has repeated the same defective practice, criticizing filing only. I worded different. Pretty much, I made it like I worded it to the point where basically I'm saying, translation, judge, you'll be dead wrong if you gave them a judgment right now. That's all I did. You'll be dead wrong. You'll be dead wrong. I cited Supreme Court authoritative and appellate court authoritative case law. In good faith, you cannot issue this judgment against them right now. Against right now. You can't. Please don't do it. Please, you can't. You know you can't. I know you can't. Velocity knows you. You know you can't. And since you can't issue a judgment right now, that means my claim stance is true, as their original was defective, meaning they never had standing, meaning there is no amount of discovery that they can even present that can cure it, meaning summary judgment.
Your right's been preserved, boss.
Surgical with this, y'all. Have faith for me. Have faith for me. Just have faith. I'm surgical with this. I'm telling you, I'm surgical. Especially I get my coffee in the morning. I hit my boom boom stick, both nose. Go to the moon for a second. I'm locked in.
You're rocking with the best.
I'm locked in. I did 3 cases today. I did 3 cases today. I did 3. One was Midland Velocity. It was I think it was LVMV. One of them. I did 3 cases. I'm locked in. For the foregoing reasons, defendant respectfully submits that plaintiff's complaint remains fatally defective. Plaintiff has not demonstrated as required by Federal Home Loan Mortgage Court versus Supreme Court case and related authority, merely insufficient to as consistently held by Ohio appellate courts. You see the undertone, what I'm saying to the judge? I dare you, it's going on appeal. It's going on appeal. Don't do it. Don't do it. It's going on appeal. You know you can't. Come on, man. Come on, man. You got to uphold the law. Come on, man. Including LVNV funding. Well, who just had LVNV funding? Pernell Elliott Williams. So y'all see Pernell Elliott Williams lawsuit versus my lawsuit.
You're rocking with the best.
Now, I'm telling y'all, and I'm not lying. Even these little TikTok people, them girls on TikTok, like, ain't nobody, I get my client, ain't none of them. None of them. None of them. And I ain't talking about just a complaint. I'm talking about discovery. I'm talking about subpoenas. I'm talking about proposed jury questions, jury instructions. Oh, yeah. I'm talking about trial, like in-court trial arguments. Facts. Or arguments. Well, you can't just rest on your motion. You got to argue. Man, what? Man, come on, man.
They're not even competent enough to be labeled in the category, man.
Right, bro. I hold mock trials against myself. Oh, come on, man. Man, I lock all the way in. These gurus will never do that. They will never do that. LVN Funding LLC versus Midland Funding versus Midland Funding LLC versus, and guess what? I had to underline that one. Velocity Investments LLC versus
same company.
The same case. You know I was going to find one against them. How do you cite a own case law against the same plaintiff that's bringing the suit? What is the wherewithal? Like, let me find cases involving them.
Like, who's doing that, bro?
Like, I don't know, bro. Professionals. Professionals are.
You're rocking with the best.
Top litigating professionals are, bro. They are. They are. Top litigating professionals do shit like that. Cover all, yes, the top ones in the world, they do that. I'm not putting myself saying I'm that by any stretch of imagination, but those are the only ones I see who does that.
And the thing is, bro, these gurus really always have something to say, you know what I'm saying? Always has some kind of insult to their intelligence towards the professionals.
Right. They all think they're right. They think they're right and everybody else is wrong for the sole purpose of saving face. That's all it's done, bro, for. They don't really believe that. but they can't lose their audience because their audience is what keeps their nose above water.
I don't have the money.
Why do you think they're online all day, every day?
That's what you call that internet.
All day, every day, because they got bills that needs to be paid. But why aren't they utilizing the same things that they teach, and at least one of their bills they don't have to worry about paying?
They can't even show that, bro.
Like I was paying $622 a month faithfully from February 2024 to July 2025.
Yeah, for like 16 months.
Yeah, right around that time. Yeah, it's around that time. Yeah. Yeah, about 6 years, around that time. Haven't made a payment since July 1st. Yo, and the first couple weeks I was like, they may send something in the mail. It's been months, bro. I don't even I know nothing is coming. I know one is not coming. I know no balance due. I know it's not coming. Wanna know why? Because in order for them to send a balance due, they were supposed to send one August. Oh, they sent one August 15th. I sent my email August 18th. That was the last time they sent it. They would have sent one September. They had to send one October. They had to send one November. They had to send one December. You see what I'm saying?
I remember. Yep.
None of it's coming. Like, I'm not even worried about that truck anymore. Matter of fact, I'm about to.
That car. It's right
Yeah, I'm about
outside.
to get it. Right. It's parked outside right now. Bro.
That shit ain't even hiding.
Like Lil, bro, I don't even hide it, bro.
I'll still sleep good regardless.
Right. The other ones, I don't even hide it, bro. If I was hiding it, that truck would be there and the black one would be in the back, like these gurus. I don't even hide it, bro. That's what I'm saying. I don't even hide. I don't even give a anymore. Like, I really don't give a about that truck for real. Like, I really don't. It cannot be conferred. That right there is saying they lost their case from the beginning. Whereas here, plaintiff failed to provide the complaint is void ab initio and should have been dismissed. That's me getting on the judge again. That's me getting on the judge again. Although the court denied defendant's motion to dismiss, the absence of standing remains a jurisdictional defect that this court must address at any stage of the proceedings. A court without jurisdiction cannot proceed to judgment. Accordingly, defendant requests that this court dismiss plaintiff's complaint with prejudice, or in the alternative, that it takes judicial notice of the binding and persuasive Ohio authority cited herein and preserve defendant's defenses for adjudication or summary judgment or trial.
You're rocking with the best.
Pursuant to rules of evidence, that's what I'm saying. These gurus will never get into the court rules like me.
Never, bro.
They'll never get into the court rules and procedures like me. One thing about me, I am high on court rules and procedure. Everything I do is going to pass the rules and procedure state. In applicable Ohio law, defendant respectfully requests that this court take judicial notice of the following published opinions, each of which is a matter of public record, readily verifiable, and directly relevant to the standing and proof requirements in consumer debt litigation. Federal Home Mortgage Corporation versus controlling case. LVMV Funding versus controlling case. Midland Funding versus controlling case. Midland Funding versus yeah, you see how I be scalping the shit out of Midland? And they got a nerve to come. They got a nerve. All right, they got a nerve to come on my people's with an $849. About to scalp this shit out, y'all. Number 5, Velocity Investments versus bam. And that's it. So basically, at the end of the day, the only way my complaint has sufficient authority and rules is the only way we can determine if that was the case is if after I responded, we just read my response. This was the court's order after the pleadings were filed. This matter has been set for civil pretrial on November 6, 2025 at 2 p.m. Prior to that time, plaintiff's counsel is directed to initiate contact with all other counsel to discuss substantial procedural issues. Let's go back and look at the word again. Let's take in what's being said and let's decipher from based on my response we just read what it means. What is really what's the underlines being said, because you gotta remember the courts, the judges, when they issue their orders and rulings, they speak in underlines. It's not so much about what they're saying, it's about the implications that it has and what it means. So I want y'all just to be following word to word and follow what it says. I want you to grasp the context and the totality of the situation based on everything I just said. But we kept saying this court can't proceed to judgment. This court should not proceed to judgment. Ohio court, authoritative courts have ruled that this isn't sufficient. Please don't give them a judgment. Preserve my right for summary judgment or at trial. Keep that in context.
Yes, sir.
Now,
Absolutely.
and the only way for you to gauge what I responded with had any legal validity, stated valuable claims, and raised material issues and facts, the only way you can gauge is what is going to be the judge's order after the pleadings are filed. You know what I'm saying? That's the only way you can gauge. That's the only way you can gauge with teachers and their arguments. This matter has been set for civil pretrial on November 6, 2025, 2 p.m. Prior to that time, plaintiff's counsel is directed to initiate contact with all other counsel to discuss substantial and procedural issues, including, but not limited to, the following: discovery deadlines, exchange of witness lists, settlement possibilities, possible amendments to pleading. See where he's throwing that out? You got to catch what's the underlinings. Evidentiary issues, including possible motions, possibility of summary judgment,
You're rocking with the
dates for further
best.
pretrial hearings, possible trial dates. You get what I'm saying? That is how you get past the initial stage.
You're rocking with the best.
That's how you get past. Now, my original, this was the actual response that we just read. But I did it like this because when I post it online, I know they get mad as shit when I don't give them the shit that they really want. I don't give it to them. When I post this video, it's all edited out. Like, you won't even hear us go over the case. We just read the response. Only part they're going to hear is, this is how you file a motion.
Sometimes you be even bleeping.
No, they ain't getting. Yeah, bleeping it out. They ain't getting. If in the Supreme Relief Team group, you ain't pay your. If you ain't pay your way, you ain't get services from me. You ain't got no own skin and invest in your own game. You ain't showing that you committed. You ain't getting. The average person off the street. Oh, teachers, what do you do next? Go learn. I don't give them. I don't give them. I don't give these nothing. Because all there is a bunch of freeloading leeches. If you can't even get on a payment plan and stick to, if you can't even do like that, they want is here. All because, well, I was scared for it, so you should give it to me for free. You. Don't get scammed again. So you had the original complaint, you had the response. Court is like January 22nd. Now you hear the judge's civil pretrial and the orders. Now, when have you ever seen a guru, as for one of their clients, ever filing this.
Never.
You only see this from the other side. When
You're rocking with the
gurus
best.
or they're filing it for their clients are the plaintiffs. You never see this when the guru is filing this on behalf of their clients. You never see this. Hell, they'll never get to this stage where they're the ones filing the summary judgment.
You're rocking with the best.
Actually, to be honest with you, looked it up today. Yeah, I'm not making these numbers up. It's less than 0.01% of pro se litigants ever moving for summary judgment.
You're rocking with the best.
It's so rare. It's like 0.01. That's 0.1% of pro se litigants that's ever moving for summary judgment. And this is what we're moving for in her case. Ever.
You're rocking with the best.
Now comes defendant, pro se, and respectfully moves this court for summary judgment pursuant to Ohio Rules of Civil Procedure 56. The pleadings are closed, the issues are joined, and plaintiff cannot establish essential elements of its claims as a matter of law. Put this together today.
Calm down, gotta relax, gotta control it, be in my zone, be in your zone, Gotta find a cure, gotta find a cure, a way to calm down, be human again, be human again, gross again, gotta find a way for a mind to misunderstood, so misunderstood. My temper is bad, my mission is good. I never be labeled as good. I never be labeled as mentally stable. They all label me as a threat. Shot me off into space, something I'll never forget. Shooting myself with these gamma rays, something I always regret. I done ran away so many times, I don't got nobody left. No friends, no love, just me and these drugs keeping me calm. Keep those comments to yourself before I go bonkers. I get green, I get mean. One man team, have your girl shaking. Then I get extra mad.